Now let's take a look at the actual Constitution as it was created at the Constitutional Convention. Article 1, which is basically the Constitution, is divided up into separate articles. Article 1 explains the legislature. It lists the qualifications for office in both the House and the Senate, the terms of office for both the House and the Senate, the method of selection, and it also calls for a census to be administered. And we'll talk about the reasons for that later, but it's basically based upon the need to know where everybody lives. In a census, you count where everybody lives, and you need to know where everybody lives if you're going to base representation on population of each state. Also lists the enumerated powers given to the legislature by the Constitution. Enumerated basically means listed, spelled out clearly, so there's no question or ambiguity with regard to what powers the legislature has. But there is also something that basically gives the legislature more power, or the ability to garner more power than in the actual enumerated powers. And that is the necessary and proper clause. And the necessary and proper clause basically states that Congress may make any laws that are necessary and proper for carrying out the enumerated powers. Of course, the enumerated powers are the listed powers, things like declare war, the ability to tax, the regulate interstate commerce. And the necessary and proper clause basically gives the Congress power to make any laws that are necessary and proper to allow them to regulate commerce, allow them to tax, allow them to raise an army or declare war. And basically, the necessary and proper clause gives Congress implied powers. Implied means that they're not necessarily listed, they're not necessarily obvious, but it's just understood that Congress needs these powers. It's implied. Uh, and we'll talk more about the necessary and proper clause, I think, when we talk about federalism. Now, Article 2 covers the executive branch, lists the terms of office, qualifications for office, discusses the Electoral College and how that works, and offers a method of removal and replacement for the president. Of course, we're going to talk about this semester. We're going to have to spend a whole chapter on the legislature and a whole chapter on the executive. So we'll go in depth later on in the semester on these concepts of terms of office, qualifications, etc. Uh, Enumerated powers given to the executive in the Constitution include commander in chief, the ability to negotiate treaties, although most treaties are negotiated in the name of the president by the State Department or Secretary of State. And then maybe one of the most important and underrated powers that the executive has is his appointment power, the ability to appoint people to offices. People, most everybody in the executive branch is appointed except the president and the vice president. And so that means the president gets to appoint all those working for him. That means those people must be loyal to him and and the president must approve of the job that they're doing, or they can be removed from office. This is in contrast to the Texas executive, where the governor is elected, but most all of the other members of the executive branch are elected separately. Uh, so the governor doesn't have great power and influence over those other members of his executive branch because uh, they're not accountable to him. But if you have been appointed to an office by the president, then you are accountable to that president, and you're more likely to do what the president wants. So there's huge power in this ability to uh, appoint people to office. And then the Constitution also states that the president must give a State of the Union report, which initially it was just George Washington would, send a document to Congress, reporting on the state of the union, how we're doing as a nation. But in modern times, it has become a television event where the president stands before Congress and gives a speech explaining the state of the union and also laying out his plan for the future. Also has a take care clause for the executive that the you know the legislature makes the laws, and the executive or the president carries out the laws. So the take care clause basically says that the president must take care to faithfully carry out the laws of Congress, basically meaning that he must carry out the laws of Congress in the spirit in which they were intended, and not try to manipulate the laws in such a way that Congress did not intend. Article 3 talks about the judicial branch and the judiciary. It establishes the Supreme Court of the United States and defines its jurisdiction. Jurisdiction is basically the kinds of cases that the courts can hear. Uh, in Article 3, that's really all that is established is the Supreme Court. The Constitution under Article 3 gives Congress the power to establish lower federal courts. Of course, the members of the Constitutional Convention knew that the country would grow over time, and by giving Congress the power to establish the lower federal courts and determine how many there would be, uh, it allowed the excuse me, it allowed the judicial branch to grow and the courts to grow without having to change the Constitution each time. Because if the Constitution stated that there was, for instance, the Supreme Court and three lower federal courts, and future and more lower federal courts were needed to be added, since the Constitution said three lower courts, you would have to change the Constitution each time you changed the number of federal courts. But by giving Congress that power, it take it that was a very smart thing to do to prevent continuous changing of the Constitution. The judicial branch will hear federal disputes and disputes between states. Uh, the judicial branch, if you remember the Supreme Court or the federal courts, you have a lifetime appointment with good behavior, is how it is stated, a lifetime appointment with good behavior. And there's some controversy in some people's minds about, lifetime appointments for judge. I, for one, am in favor of lifetime appointments for judges. And we'll talk more about that when we talk about the judiciary. Um, and then one of the most fascinating things I find about the the Constitution and how they address the judicial branch is that there are no qualifications listed to be a member of the Supreme Court. No citizen qualifications, no age qualifications, no education qualifications. You don't even have to be a lawyer. There are no qualifications listed. But the process of choosing the judges kind of weeds out the ones that aren't qualified, and we'll talk about that when we talk about the chapter on the judicial branch. Article 4, full faith and credit clause and admitting new states. The full faith and credit clause basically states that each state must honor and respect the judicial proceedings and documents of other states. Things like driver's licenses and marriage licenses, you don't have to change. Um, you don't have to get remarried every time you move to a different state, because every state gives full faith and credit to the marriage licenses of of the other states. Article 5 talks about amending the Constitution. We'll touch on that in just a second. Article 6 has a supremacy clause, which basically says the Constitution is the supreme law of the land, that there are no other laws that supersede the U.S. Constitution. And Article 6 also states that there is no religious test for holding office. We're always all familiar with, the First Amendment that talks about freedom of religion, Establishment Clause, and the Free Exercise Clause of religion, which we'll talk about later in the semester. But also, freedom of religion is in separation of religion from government is stated in the Sixth Amendment, when they state that no religious test shall be given to hold any office under the United States. Article 7 talks about ratification of this very Constitution, because this is just the document. It hasn't been ratified yet as they are writing it. So Article 7 says if 9 of the 13 states ratify the Constitution, then it will then become the law of the land. Now, the amendment process, if you're going to change the Constitution or amend the Constitution, there are two ways of proposing an amendment and two ways to ratify an amendment. The first way to propose is a two-thirds vote of both houses of Congress. That is the way most all uh, amendments have been proposed. Or you could do a national convention called by Congress on the request of two-thirds of the states. Um, Ratification, approval by state legislators of three-fourths of the states. So Texas, the legislature in Austin would be one of those states that legislatures that would be charged with approving or ratifying a constitutional amendment, or approval by ratifying conventions in three-fourths of the states. So there are two ways to propose and two ways to ratify. The most common process, of course, is two-thirds of votes of both houses of Congress to propose, and then approval of the state legislatures to ratify. Now, the ratification debate, basically, this idea that they must approve this Constitution or ratify this Constitution came down to a division between two different groups. One, the Federalists, who supported the Constitution as it was written, and then the anti-federalists, who didn't necessarily like the Constitution as it was written, and demanded more protections, more freedoms, and protections for the states and the individuals against a strong national government, because the new Constitution gives the national government much, much more power than than it had under the Articles of Confederation, and the Anti-Federalists feared this. So, who were these Federalists and Anti-Federalists? Well, the Federalists were property owners, the landed rich, uh, merchants of the Northeast and Middle Atlantic states. The Anti-Federalists tended to be small farmers, shopkeepers, and laborers. Although there were some plantation owners and wealthier people like um, uh, Jefferson and Madison were wealthy in their own right and the large plantation owners, but they also were anti-Federalists. Their political philosophies, Federalists were elitist. They saw themselves and those of their class, the elite class, the educated class, as most fit to govern. Others were to be governed. So, in a lot of ways, they felt like you were. There were some people were better than others, and those people needed to be the leaders, those that govern. The Anti-Federalists believed in the decency of the common man and participatory democracy. They believed that the masses could govern themselves. They viewed elites as corrupt, and they sought greater protection for individual rights. Type of government favored, of course, the Federalists, because they supported this new Constitution, favored a powerful central government, two-house legislature, and removing the masses from the process of governing. Uh, they distrusted the masses. They saw them as only seeking their own selfish, small interests, not looking at the big picture. Of course, by distrusting the masses, that shows in the fact that really, under the Constitution, the only entity that is elected directly by the people are members of the House of Representatives. Everybody else, there are filters to prevent the masses from choosing them directly. The Anti-Federalists wanted stronger state governments closer to the people, smaller electoral districts to make the representatives more accountable, frequent elections, referendum and recall, which allowed the masses to determine policy. Um, in alliances, in general, the Federalists were pro-British and anti-French, and this will play a big part when it comes to the French Revolution. Pro-British and anti-French, and the anti-Federalists tended to be anti-British and pro-French. Now, the debate over the ratification of the Constitution basically centered around competing essays published in newspapers throughout the states, uh, arguing one way or the other, whether the Federalists arguing for ratification of the Constitution, the Anti-Federalists um, arguing against. In the end, history has told us that the Federalists, of course, won, and their Federalist Papers, a list of 85 essays that were published across the country, trying to explain how the Constitution would work, why it would work, why it would prevent tyranny, all these things, why it would prevent factions from developing and taking over government, describing the separation of powers. These were the most persuasive, and to this day, they're the very best documents for understanding what the Constitution means, what the purpose of it was, why it was structured and the way it was, and why different items were put into the Constitution. So, just for our purposes today, I hear people all the time on television talking about, well, this is what the Constitution means, or we're not following the Constitution because we're doing this or that. Well, most of them don't know what they're talking about, and if they really wanted to know what the Constitution means, they would just read the Federalist Papers, and it would explain it clearly. The Federalist Papers were written by Alexander Hamilton, James Madison, and John Jay. The majority of them, of the papers or essays, were written by Hamilton and Madison. Jay got sick after writing a few of them. They were published in a pseudonym under Publius. Uh, the Anti-Federalists, they wrote their essays and they tried to make their arguments, but they were not as persuasive. Uh, that their arguments that this would be a tyrannical national government, that it would have the potential to strip away state and individual rights, wasn't as persuasive. But they finally got the Federalists finally got the ninth state, New Hampshire, to ratify on June 21st, 1788. So that's the official date that that the Constitution was ratified. But there were still four states, of course, that had not ratified the Constitution: New York, Virginia, North Carolina, and Rhode Island. And their holdouts, especially New York and Virginia, which were two of the largest, wealthiest, most important states, you really couldn't have a legitimate constitution if you did not have those two major states involved. Uh, and one of the arguments for not ratifying it was there was not enough protections, as I mentioned before, for personal freedoms and state liberties. And so, to alleviate that problem, the Bill of Rights was added. The Bill of Rights consists of the first 10 amendments to the U.S. Constitution, and it was adopted into the Constitution in 1790. Uh, we'll do a whole chapter on the Bill of Rights when we talk about civil liberties, but just know that these were uh, amendments placed into the Constitution that protected the rights of individuals, especially individuals, but also the states. Things like freedom of speech, freedom of the press, the right to a jury trial, those things uh, cannot be infringed upon. This is a graphic that shows the ratification and, in what order that the states ratified the new Constitution. Delaware was first. Some of the states, like Delaware, it was unanimous, and wasn't even really a debate at all. Other states, it was a very close vote. States like Massachusetts, states like Rhode Island at the very end, New York, Virginia, those holdout states had very close votes. But it does show that everybody was not completely on board with the new Constitution at the time that it was ratified. This is just a quick summary of the freedoms guaranteed by the Bill of Rights. The First Amendment: freedom of religion, Establishment Clause, Free Exercise Clause, freedom of speech, press, assembly, and petition. Second Amendment: the right to bear arms. Third Amendment, which isn't really relevant anymore, but housing and quartering soldiers in times of peace. Fourth Amendment: protections against unreasonable searches and seizures, which is a controversial one now, with the USA Patriot Act and NSA spying revelations that have come about recently. Fifth Amendment: grand juries, um, double jeopardy, self-incrimination, pleading the fifth. Uh, and then Sixth Amendment: speedy and public trials, impartial juries, the right to face your accuser, and the right for it to have a lawyer. Uh, Seventh Amendment guarantees the right to jury trial in civil cases. Eighth Amendment prohibits excessive bail and cruel and unusual punishment. Ninth Amendment mandates that those rights not explicitly listed in the Constitution are reserved to the people. Uh, and Tenth Amendment mandates that those powers not delegated to the national government are retained by the states and the people.